I'm not. And as you just saw, this meeting is being recorded. So as we usually start, I'd like to, anyone who is new to us, who wants to introduce themselves in the chat, go right ahead. Please do that. We have a number of visitors today for different presentations. And I will take a moment to say, not only are we going to do comings, but unfortunately, we're also going to do goings today. And we are sad to see our colleague Lindy Lawrence leaving us, but after 6 years of incredible board service. So any comments from anyone about, I mean, Lindy's services, her service record is so remarkable and long, I couldn't possibly cover everything. But comments, Sal?
I just want to say this. I mean, Linda and I joined the board at the same time, and I kept on telling her, especially those first 2 years, quit saying yes all the time. I mean, you're starting off law school, you've got 2 kids who need your attention, you're involved with other organizations, and yet she would keep on doing that, much to my chagrin. And she did it with such energy and spirit and enthusiasm that it's just infectious. And I can't say enough about my friend Lindy and what she has done before she joined the board to promote access to the legal system, what she's done since she joined the board, and what she's doing now. I mean, for those of you who get a chance to talk with Lindy about now that she's a lawyer and starting her own practice and helping clients who need help. She's amazing, and I can't tell you, Lindy, how much I will miss you being on this board.
Thank you, Sal. I see Laura Bradley.
Good morning, everyone. So I'm reflecting back to the days when Lindy and I were meeting in downtown Tacoma to talk about the Access to Justice Board and her plans for the future. And I just want to say I'm totally in awe of Lindy. She is so smart and so dedicated and just has really fantastic ideas. So I agree, it's a loss to the Access to Justice Board, but I'm just excited to see where the future takes you and hope you'll stay in touch and let me know what you're up to.
Thank you, Laura. Caitlin.
About it, and I want to thank Linda for all she's done for the Alliance over the past few years and how grateful I am. One thing that really comes to mind for me is Lindy's work in setting up our, working with our team to set up the law-related fundraiser group, which has been a huge benefit to the Alliance. And I'm full of appreciation and gratitude, all the good feels for Lindy. So
Thank you, Caitlin. Diana.
I just wanted to join the choir and sing Lindy's praises, and just as a staff to the board, wanting you to know that you are leaving many legacies from something very seemingly minute, like when you're on the budget committee, helping us to sort of redo the budget spreadsheet. So every time I look at the budget, I always think of you. And then bigger things like the legal aid and fundraisers committee, and then bigger thing like our website, the complete redesign. So I see Lindy in many places that will continue for a long time. So just want to express my appreciation to you, Lindy, for all the work you've done.
And there's some also lovely comments in the chat box. I will just say, to me, I will miss you and your incredible ability to sum up complicated issues in a very clear and succinct way. I have been so impressed. So pretend that this is your Flame of Justice Award and that this will be coming to you sometime soon. We will figure out how to make that happen. But We have not forgotten you. Anything that you want to say?
I just wanted to say thanks so much. This is a wonderful community to be part of, and it's inspiring to be around people who do this work either as volunteer or as their chosen profession. And it has been an experience that I will not soon forget. So thank you to everyone.
Thank you. All right. Going back to our agenda. So the March meeting minutes need to be amended to include Mike Chin as attending. But with that addition, are there any other additions, changes, amendments to the minutes? Is there a motion to approve the minutes?
Move to approve as amended.
Thank you, Sal. Is there a second?
Second.
Thank you, Michelle.
Mhm.
All right. All in favor of approving the minutes? Aye. Anyone opposed? Anyone abstaining? Okay, the minutes are approved. I believe that Judge Keenan will has to actually be on a docket this morning, so he will be joining us later. So I think we will then go into the presentation from our visitors. Pamela Pizza, sorry,
No,
and
you're fine. It's Beats.
Beats, and Christopher. I'll ruin this one too.
No, it's just like the food. It's easy. Just like the food.
Christopher Berger.
There you
So excellent. So Pamela is here from the Utah ATJ Commission. Excellent. And Christopher is here from NLADA, the National, I get a lot of
Legal
emails.
Aid and Defender Association.
Great. So welcome. We are very happy to hear from you.
Pamela, do you want to start with your overview, or would you prefer if I went first? Sorry, we didn't discuss this.
I think it might make sense for you to go first to lay out the landscape of it.
Yeah, so I'll try to give a very quick kind of 10-minute overview of where some of these lawsuits are right now. And I'll begin by talking about what do I mean by some of these lawsuits. There has been a coordinated attack on mandatory state bars throughout the country. And that's particularly important to access to justice commissions because the ATJ activities are sometimes front and center in these lawsuits. Are across different circuits. Goldwater Institute, which certainly seems pretty well organized on this as they seek out different circuits. Some of them are kind of more independent actors, but it fits within a larger scheme. And they're all focused on essentially that it is a violation of their First Amendment rights. One, the first argument is to be forced to join a bar at all. If the bar says anything, if the bar does anything, that they are being forced to associate, that's compelled speech, and therefore they should not be forced to join. The other issue is their dues, is that whether or not they're forced to pay dues and whether or not simply being refunded a portion of their dues is sufficient if the bar does anything, says anything that they could possibly disagree with. This started to come up, well, it came up about 30 years ago in Keller versus the State Bar of California. And in that case, the court held that a state bar cannot finance ideological activities with mandatory dues, but they can require membership, they can require dues, but those dues have to go towards what they call germane activities, activities related to regulating the legal profession and improving the quality of legal services. And since then, that has always been the test. It's always been the concept of, is this regulating the legal profession or is this non-germane political activity? And what the issue that came up though is that Keller rests on a whole slew of cases that come out of the constitutional issue of unions. First, private sector unions with railway companies that were challenged, but then in public sector unions in a Boot versus Detroit Board of Education about whether or not you can force teachers to become part of unions. I promise it's not just a tangent. What happens is we have in the not so distant past, we have Janus, which is a case before the Supreme Court about public sector unions in Chicago. And that gets struck down, that it is declared unconstitutional to force people to join a public sector union. And what it rests on is this idea that public sector collective bargaining is inherently political, is what the court finds here. And therefore, any dues, even the central purpose of that public sector union, is political, and you can't force people to pay dues or join. So once that occurs, you had a case in the Eighth Circuit, Fleck versus Wetch. And in that case, there was a discussion about opt-in versus opt-out process for non-germane expenditures. And it kind of fell pretty squarely within Keller. It related to some activity the bar engaged in related to some family law issues, and this individual attorney objected to them, said that they couldn't force him to be part of a bar and pay dues for these types of things. And the Eighth Circuit said this clearly falls within Keller. It's a germane, non-germane issue. You guys have to work out your opt-in, opt-out process, maybe a little bit, maybe some notice issues, but it's not a particularly novel issue. He petitioned for writ of certiorari in the Supreme Court, and the Supreme Court then decided Janus, then remanded it back to the Eighth Circuit and said, hey, we just decided Janus, which this case kind of rests on the same premises that Janus overruled. You might want to take a closer look. That opened this huge door. Now, in that Eighth Circuit case, they said, thanks for telling us to take a more careful look at it. Same conclusion. He goes back to the Supreme Court. The Supreme Court denies cert. That case is done. Meanwhile, you have these cases popping up all over the place. You have in Oregon, you have Crow versus Oregon, which came through the Ninth Circuit. It's been remanded back to the court to look at not the dues issue, but this freedom of association issue. They were denied cert by the Supreme Court on October 4th. And then you also have a case out of Wisconsin called Jarko versus State Bar of Wisconsin, where they got the case dismissed. The plaintiff actually asked the Seventh Circuit if they could dismiss the case on an accelerated schedule. The strategy was clear from the start. They were trying to get in front of the Supreme Court. So they essentially asked the Seventh Circuit to find against them. They go to the Supreme Court on a fast track, and the Supreme Court denies it. And at that point, we kind of thought, hey, I think these things might be going away. Meanwhile, though, the Goldwater Institute had a case in Oklahoma. They had a case in Texas. They had a case in Louisiana. And just to give you a sense of the coordination here, and there's another case in Michigan, and that gives you cases in the Fifth Circuit, the Sixth Circuit, the Seventh Circuit, the Eighth Circuit, the Ninth Circuit, and the 10th Circuit with no repeats. These are not just individual actors who happen to, on accident, stumble upon a First Amendment claim. They're clearly targeting multiple circuits, hoping for some type of circuit split, hoping to get the attention of the Supreme Court, and I'll get in a moment to whether or not that's working. And to give you a sense of some of the things they complain about, I think it's really important, especially in this audience, to think about that. What they're saying is that when the bar engages in certain activities, that is compelled speech, but it's not simply political statements. The different lawsuits make different arguments, but some of the things that they have complained that the bar engages in that's inappropriate, violates their First Amendment right, is addressing the civil justice gap, increased resources for state public defenders, taking a position on increased legal services corporation funding, positions on juvenile justice reform, elder law reform, addressing sexual harassment in the legal profession, bail reform, supporting access to justice activities. So I think it's important to note that it's not a situation where state bars could say, well, we're going to tamp down some of our political statements, and that would make the issue moot. That you do see, though, perhaps the most interesting case in terms of what's happened so far is a case out of the Fifth Circuit in Texas, McDonald versus Longley, also filed by the Goldwater Institute. That there we actually have a decision out of the Fifth Circuit that actually got into the nitty gritty. It didn't dismiss on standing or some type of procedural ground, but it looked at all of these large scale claims that the plaintiffs were making that were non-germane activities and inappropriate. And they found that the legislative program of the State Bar was not germane. And that it was inappropriate to force people to join the bar when it's engaging in not germane activities. And so they remanded it to the district level to say, you need to fix this, you fix these things, you can force people to join, but you have to be limited to germane activities. So when they're advocating for changes in substantive law, like civil unions in the state constitution, less controversial family law changes, things like that, that's not germane. When they're looking at things like exemptions regarding appointments of pro bono volunteers, that would be considered germane because it relates to the regulation of the legal profession. The same thing with diversity initiatives. And there the court addressed that head on and said, hey, we understand this may be seen as controversial by some people in the profession, but it relates to regulating the legal profession. It's appropriate. Having a legal access division, directory of volunteer and resources, and charging a legal services fee to help fund legal services is also germane. They did find, though, that the Access to Justice Commission and funding that in Texas was not germane, but particularly because of some of the activities the Access to Justice Commission was engaging in. So Texas is kind of working through that right now, figuring out how to address the Fifth Circuit Court's holding. So while it could be said, and I did say it earlier, that looking at this from is there any way to make these lawsuits go away by trying to tamp down political activity? Absolutely not. But depending on what a court finds, it may make a difference. I think our position, and each state can do as they please, but our position would be to not get too tight in tamping down activity, because you don't know what the courts are going to decide. You don't know what your circuit court or your state courts or your district courts will decide on any of these constitutional claims. And you don't want to take away programs that might be found constitutional. So I did mention that prior to the Texas case in the Fifth Circuit, after the Wisconsin case was denied cert, we kind of thought that these were going away. But even though with a partial victory for the plaintiffs out of Texas, they still filed cert with the Supreme Court, as did a case that lost in Michigan. They also filed for cert, and a case out of Oklahoma also filed for cert with the Supreme Court. Now, the cases that do have a pending petition for certiorari before the Supreme Court, out of Michigan, out of Texas, and out of Oklahoma, those have all been scheduled and then rescheduled for conference on, believe it or not, today. So the Supreme Court will be looking at those cases. I'm less optimistic that they're all scheduled for the same day. That could potentially be read as the Supreme Court is taking this seriously and wants to handle them together. But at that point, I think it's a little bit like reading the tea leaves here and really speculating. We just, by they, I'm sorry, I mean by the Supreme Court. By the Supreme Court putting all of these cases on conference for the same day and handling them together, it could be read that the Supreme Court is taking it seriously and considering granting cert. At the same time, they've had very similar cases out of other circuits and denied cert. And kept the state bar and everything else that it's doing in place. So it's really hard to know, and I think trying to predict it is really a guessing game at this point. So I will stop there and hand it over to Pamela, but that's the landscape of where we are with the lawsuits.
Thank you, Pamela.
Thanks, Chris. I think that really sets the stage. And one of the reasons this has been so important to the Utah Access to Justice Commission is because our Utah State Bar is also one of the associations being sued with this type of claim. And we're in the process, we're still at the district court level. But it's led to our commission really taking a deep look at what are the activities that we're doing, what is the purpose of this commission, and what are some strategies moving forward to stay within the bounds of what's appropriate for a mandatory bar and consider other options and other ways to get access to justice. So at the core basic function, an Access to Justice Commission is meant to give high-level oversight. It's meant to help with planning and education, developing resources, improving delivery systems, and really bringing together all of the key stakeholders in a state and giving them the opportunity to focus on access to justice, to really assess needs, to do research, develop strategies, and then evaluate their processes, right? So that's why we're here. That's the point of our activities. And I think every state is different in how they choose to do those things, right? What they focus on, what the key issues are in their state. And that's important to keep in mind, that no two access to justice commissions are going to look the same or are going to act the same or be evaluated the same. So when you see something happening in Texas or in Utah or Louisiana, it's going to be different and viewed differently than what you're doing. Currently, if you look at US states and territories, there are 28 mandatory or unified bars. They can be called either one. These are the ones that have been, much of the focus of the litigation. There are 22 voluntary bar associations, and that is where the lawyers are not required to pay dues. It is done on a voluntary basis. They all look very different. Many of them were designed that way in the beginning. Some of them have changed over time. And then there are 3 bars that have been bifurcated. So they have a mandatory arm that focuses on things like discipline and licensure and the practice, regulating the rules and practice of lawyers. And then they have a voluntary arm as well. And that is where advocacy and access to justice and those types of activities live. Of these 3, 2 of them switched from a mandatory bar system to this bifurcated system, specifically because of this type of litigation brought. So they assessed their circumstances, the lawsuits that were coming, and that was the option they decided to do as a way to handle the lawsuit. I'd like to focus on one of those states. The 3 bifurcated bars are California, Nebraska, and Virginia. And I'm going to focus on California. I think it's an interesting case study in what happened. They were sued. They looked at their activities and felt that the best way to move forward was to come up with a formal structure to divide their activities. It was signed into law in 2017, so this is recent. This isn't like a long time ago. This is something that happened, just before COVID, and they're still in the process of figuring out what this looks like. It's been pretty successful. They have their mandatory bar section, and then all of the specialty law sections, all of the things that could be moved into the voluntary system were, and it was grouped under the California Lawyers Association. So you have the California Bar Association doing mandatory things, and the California Lawyers Association as this voluntary nonprofit that launched in 2008 when the law took effect. So they really took a strong stance in saying, One side is going to focus on licensure, on admissions, on discipline. The other side is going to look at the more trade-like association activities and in developing new initiatives. They have, more complex things along with that I won't get into. I think it's confusing. But for this purpose, the idea is that, again, every commission is different and there are different options. Some are more formal, like saying we're actually going to split this association into two. So, or we're going to completely switch from a mandatory to a voluntary. But there are other possibilities. It doesn't have to be an either or situation. And that's what I appreciate about what Chris said, is that, it's not like there's magic words or choices that you can make that will give you this blanket protection of, okay, we're fine, there's not going to be any issues. But it's looking at activities and plans and saying, is this something that we can support, that we can do to navigate through these complex times? In Utah, like I said, we are really faced with this head on right now. And some of the things that we are doing, it sounds like your state is also considering. So the Utah State Bar helped to support and develop the creation of regulatory reforms in Utah. And we now have a regulatory reform structure that is done under the courts, under the Supreme Court. So it's separate from the bar. It's done as its own completely separate thing, but it has really helped increase our options for access to justice activities in bringing in legal advocates and bringing in other professionals who can step in and help meet some of those activities in a different way, excuse me, in a different way from the traditional ways that our commission has looked at. We have also developed a licensed paralegal practitioner field, and that is another way we can provide access to justice options for lower income people to receive legal services in a way that is regulated but different than some of these legislative options. So those are two ways. Another option that Utah has done is really focused on education. So community outreach and trying to get upstream before it enters the legal process and finding ways to support those activities. And then the other thing that we have done is focused on that profession of, we want to improve access to justice regardless of which side of a lawsuit you're on. So for example, we have pro se calendars where we help people who are going through evictions or getting sued for debt collection purposes. We provide volunteer lawyers, and most of the time that means providing lawyers for defendants. That's the primary purpose of it. But if a pro se landlord comes in and has no idea what type of notice to file or how to get someone who may be a bad actor out of their unit, we've deliberately said we're going to make sure that we find ways to provide representation on that side too, so that it's the access to the law regardless of who you are and what your intent is, instead of just focusing more narrowly on one side. So that's what we've been doing in Utah. If anyone has any questions for either Chris or for myself, we're certainly open to discuss this.
Thank you, Pamela. And you took my line. Does anyone have any questions? So I see Caitlin, and then I see Sal.
Okay, good. I've got a good backup. I'll be quick, Sal. I think this is a really, really big deal. And I'm so grateful for Michael and our colleague from Utah for joining us today, because I think this has some direct and indirect consequences for the Alliance and for our clients, both short-term and then downstream consequences that we might not have even thought about. And one thing I feel like I've been remiss in the last couple of years, because of, the times we are living in, is, where is our Board of Governors, or the bar's Board of Governors, maybe more correctly, and our court on this? Understanding that a lot of this litigation has occurred at the federal level, I'm just kind of wondering where we're at. And Sal, maybe you're the best situated to respond to how we're doing in Washington right now on this. You're muted.
Yeah, I wanted to stay muted once you asked me the question. I'll address your question, but just on a very superficial way, because I think that's my knowledge. I know the bar actually the state Supreme Court has looked at this. They've engaged the bar. They went through a study a few years ago and decided not to change anything. That's kind of my superficial knowledge, and I'm sure others on this screen have much more knowledge than I do. But it is on, my understanding is on everybody's radar screen, including the Bar Association. The bar is looking at this as well. And everybody so far is holding pat. I share obviously the concerns of everyone here as to what this means for the ATJ board, especially since this is our focus. So my question to Chris, I'm curious, because you said, and I think you said the Fifth Circuit was upholding a lot of things, except for Texas's ATJ Commission for some of the actions that the commission has engaged in. Can you elaborate on what acts the Texas ATJ Commission has engaged in that was problematic for the court?
Chris, you're muted.
Of course. You think after 2 years we can figure this out. So in the Fifth Circuit, to give kind of a short summary, it said the funding of the Access Justice Commission is not germane because it did more than help low-income Texans access legal services, that they had activities aimed at making and changing substantive law. Anything, well, no, that goes to more general bar association there, that quote, but that was the issue, is to the extent that it was aimed at making or changing substantive law. And that was a big thing for the Fifth Circuit. And they made a point to highlight both a very minor change in family law that I think was kind of universally agreed upon, of just a procedural issue, and something that was more of a hot button political issue, and saying that both were non-germane, that it had nothing to do with whether something's politically contentious, but it had to do with changing substantive law. So I don't think Texas is going to disband the Access to Justice Commission. I think they're going to just try to think a little more carefully about their activities to make sure it can't be interpreted as changing substantive law.
Thank you. Esperanza, and then Michael, and then Jim. And there's a comment in the chat box from Diana about the bug.
Thank you, sorry. Yeah, I had a question for Pamela. And just, I also wanted to respond to the question, Caitlin's question around what's the bar's position and what is going on in Washington State. I was part of that work group that discussed this issue not too long ago. And I think that everybody was very clear that this was not going to go away, that this was, I think, our state's effort at responding at the moment and kind of really putting it on the radar so that we can be aware of what's going on, and for those that are interested to kind of dig in a little deeper, because it's going to be something that's ongoing, and here we are. But the question I have is in regards to the access to law regardless of intent for both sides. Do you, how do you consider income, low income, those kinds of things when you're deciding who to represent or how to provide, who gets those kinds of services because of the, I mean, it's not like there's large amounts of resources to deal with the lack of access. And so who gets that access and who doesn't? How do you reconcile that?
We actually have different programs to meet different needs. So for example, on our pro se calendars and on in our virtual legal clinic, we do not screen for income because the likelihood that someone is being evicted or being sued for debt collection purposes when they have enough resources to pay for them seems so low that this is one of those choices we make where we just don't even screen. If you are on this designated calendar or if you are coming to this legal clinic, we are presuming that you need help and that we're going to find ways to give it to you. So these are open really to anyone without boundaries. We also have a modest means program. And this program is designated for lower income who don't qualify for free services. So these are people who fall between 125% and 300% of the federal poverty guidelines. And if they qualify for this program, after being screened, then they get reduced opportunities for lawyers. So in other words, you know, if a traditional lawyer is charging $250, $300 in the modest means program, they will very specifically limit their fees to either $50 or $75, depending on what the person qualifies for. So that's one of those middle programs that allows people who may not qualify for free services to still find a way to have access to the justice system when they are completely out of the ability to pay traditional fees. And this comes up a lot in rural areas as well. And then we have the traditional, you know, true low income poverty type programs that we do screen, and you do have to be under that 125% range.
Thank you. And then Jim, last comment or question.
Thank you. Allow me to lower my hand. So I put in just a brief synopsis of the history of the last drive down this highway. The commission that was established by former Chief Justice Mary Fairhurst held hearings across the state, virtual hearings, took tons and tons of testimony, and came out, and many of us, including the Office of Civil Legal Aid and the King County Bar Association, were very actively involved in the conversation. And the lay of the landscape is not, and Chris, correct me if I'm wrong, but was not then substantially different than it is today in terms of the coordinated, consistent, deliberate attacks on the unified bar. A number of us strongly encouraged the group to make, I guess it was the Board of Governors, to make a recommendation to the Supreme Court to bifurcate and to take the regulatory and near regulatory functions, including access to justice and professional diversity, into the mandatory regulatory bar under the direct authority of the Supreme Court, and to reestablish the Washington State Bar Association or some successor organization as a membership, a voluntary membership association, focused on member-related needs, issues, supports, essentially traditional trade associational activities. The court and KCBA and OCLA both filed letters on this. I think KCBA's was in August of 2019, and ours came shortly thereafter. KCBA's letter, by the way, was an extraordinarily clear articulation of not only why, but how we could have accomplished this task. We will be, these letters will be reproduced in the upcoming Bar News at request of WSBA staff, editorial staff. And we have, both KCBA and OCLA have reaffirmed our positions that this is the right way to go for the reasons articulated principally in the detailed letter of the KCBA, in the details of the KCBA letter. I'm happy to shoot that letter out if people do not have it. But this isn't going to go away. We can, if the court has the courage, which it didn't have in September of 2019, if the court has the courage to basically take the initiative and define it the way it needs to be and wants it to be defined, particularly not only consistent with the laws and expectations that are generating out of Supreme Court jurisprudence, but also with the terms and commitments of the Supreme Court, our Supreme Court's June 4th, 2020 letter, and kind of the pivot that we are all collectively undertaking in that sphere. And that all is regulatory and or near regulatory. So I think we have, again, time. I think if people are interested in this issue, comments should be sent in. And hopefully we can switch a vote on the Supreme Court.
Thank you, Jim. And thank you very much to, sorry, Caitlin, to our visitors. We have a packed calendar agenda this morning. So thank you to Chris and to Pamela for coming and for your presentations this morning. Really appreciate it.
Thank you so much for having us.
Thank you.
And Caitlin, if you want to put your question in the chat, I'm sure we can address it there.
Okay, thank you.
All right, so I see Judge Dave Keenan has joined us. So we're going to go backwards on the agenda to the discussion of the rules, the proposed rules, and the motion by the ATJ Rules Committee.
Thank you, Terry. So I'm going to go over 4 rules. 3 of them are in the Code of Judicial Conduct, but they're kind of in 3 different tranches or bundles, if you will. So I'm going to start with the bundle of Code of Judicial Conduct Rules 2.2 and 2.6. These come as a motion from the Access to Justice Board's Rules Committee that I chair. And the motion is that the ATJ Board write a comment to the Supreme Court in support of the amendments to Code of Judicial Conduct Rules 2.2 and 2.6. If the motion is seconded and approved, I'll likely work with Francis, the board chair, to draft a letter in support. Comments are due by April 30th to the Supreme Court. These proposals come from the Superior Court Judges Association, and specifically the Superior Court Judges Association has an unrepresented litigants work group. Some of you are familiar with that work. I know Jim Bamberger is familiar with that work. I'm a member of the work group. Jim is a member of the work group. It's led by Judge Forbes, who's the incoming president of the Superior Court Judges Association. The discussion in relevant part in that work group is that there are many unrepresented litigants appearing in our courts, and I can tell you firsthand as a judge in family law, I see that all the time, and that judges are not clear on what they can do in ensuring an unrepresented litigant's right to be heard without appearing to be partial to the unrepresented litigant. In other words, the concern is some judges feel like, well, here's a case where I have an attorney on one side and no attorney on the other side, and this person seems really confused, but I don't want to appear like I'm favoring that person, so what can I do? And the rules already tell judges that they can do some things, but they're not explicit. And some judges understandably are very cautious, and others are maybe a little bit more aggressive in the assistance that they might want to try and provide unrepresented litigants. So starting with Rule 2.2, right now, that rule has a comment 4, and which says that it's not a violation of a judge's duty to be fair and impartial, to make reasonable accommodations to ensure pro se litigants the opportunities to have their matters fairly heard. The proposed change to the comment, and you can see this in the board's agenda that was sent out for today's meeting, you can link to it, would add some details to comment 4 to be more explicit on this point. 2.6 is really where there's quite a bit more. 2.6 is titled Ensuring the Right to be Heard. And the proposal is to add a new comment, a comment 4, which provides a non-exhaustive list of steps a judge might take, but is not required to take to facilitate the right of unrepresented litigants to be heard. In other words, not to favor them, but to maybe begin to even approach leveling the playing field. And I don't think this will level the playing field, but it will help some judges, I think, who are unclear on what they can do to understand, here are some examples of things that you can do. Many of the things on the list judges are already doing. I already, for example, of course, let unrepresented parties present their testimony in narrative form, because I'm not going to have somebody sit next to me on the stand and ask themselves questions. So that is the first motion from the Rules Committee. And what I would hope for is a second and then maybe some discussion.
I don't think
I
it
will
needs
second. I will second the motion, even though it probably doesn't need it, but I will second it.
Any discussion? Sal.
Yes, and we talked about this briefly at the working session, so I'll keep my comments in line with those. I'm baseline, I'm in favor of these rules. One thing about our system, though, it won't, and I think I agree with Dave, it still won't equal the playing field, nor can it. Ours is an adversary system, and it works well when the adversaries have the same amount of resources, or at least within the same kind of zip code of the same amount of resources. And it doesn't really work when one side has far more resources than the other side. And that's why I'm in favor of this rule. I do have concerns. I think it makes more sense in the bench trials, where the judge can ask questions, and that's where you're less worried about, obviously, the effect on others. But a judge's comments, even questions, may have an impact upon a jury as to which side the judge feels is the right side, if you will. And for those of you who do trial work, you all know that you get a jury instruction at the end of trials by the judge telling jury, if you think that anything I've said is a comment on the evidence or trying to favor one party or the other, you must disregard that to the extent that that works. That's the problem I have with subpart 5 of 2.6, asking neutral questions to elicit or clarifying information in a jury trial. Almost by definition, any question that an attorney asks, you're asking it for a reason. You're asking it to favor your side. And so I think it's very difficult for a judge if they're asking questions. Unless it's a foundational question, which is addressed under subpart 12, which I certainly agree with. But other than to making a foundation, there's a real risk of having the judge, in effect, by asking a question, comment on a question. And again, anybody who does trial work, you know that jurors get to ask questions, and oftentimes, especially for the attorneys, we pay close attention to the questions being asked, because we want to know that usually a clue, or can be a clue, as to how that particular juror is feeling about the case. And sometimes it's very open about how they feel. So I do have that concerns. With that being said, I will make it very clear, I'm in favor of the adoption of these rules, and I urge that the ATJ board write a letter, as Dave said, in support of them, and I will voice my comments to the court in a separate letter.
Thank you, Sal. Any other comments about these rules? Michelle.
Hi, thank you. I just want to comment that I agree. I think that these guidelines are really important to help, again, try to level the playing field while not at leveling it at the end of the day. And yeah, I understand Sal's comments, but I think it's just important to remember that these are guidelines. They're not directives for things that the judges should be doing or necessarily, that the things that the judges have to do. And then I also think that certain ways to address some of the concerns that Sal raised would be just, making sure that there is sufficient training with judicial officers to make sure that there are ways that are worked out in order to, like, how do we best put these strategies into use in a way that is fair to all parties. But I absolutely support this.
Jim, I see your hand up.
Thank you. So as Judge Keenan noted, I sit on the committee that worked with Judge Forbes and other committee members to generate these clarifying recommendations. They don't change the canon, they don't change the law. And I just want to assure everybody that they were developed in close consultation with Rachel Kullner, who's the head of the Commission on Judicial Conduct, whose message has consistently been, you could do all of this stuff, but it would not hurt to have it clarified in the comments to the code. So this is, SCJA took it all the way up through their governance and it was adopted there. And it's a pretty straightforward, I recognize, as Sal points out, there may be circumstances where counsel perceive a judicial officer running astray from the letter and spirit of the canon in exercising any one of these prerogatives. But again, as Michelle says, these are not mandatory. These are just guidance to judges to help them understand that it's not black and white. They have to look at it contextually, but they do have authority under the right circumstances to do any or all of these things.
Thank you, Jim. All right, so there's a motion and a second to approve a comment from the ATJ board in support of these rules. All board members in favor, aye, or raise your hand. Let me see. Okay, anyone opposed or abstaining? All right, so that motion passes.
I'm going to move on to the next two rules. Unfortunately, I have about 3 minutes before I have to return to the Uniform Guardianship Act calendar that I left. So we're going to move on to rule, we're still within the Code of Judicial Conduct. We're now on rule 2.3. This also comes as a motion from the Rules Committee that the board write a comment in support of the amendment to 2.3. And again, if it was seconded and approved, I would work with the board chair to write a letter in support to the Supreme Court. Rule 2.3 deals with bias, prejudice, and harassment. And this amendment would amend comment 3 to track with Washington law, adding gender identity and gender expression as impermissible bases for harassment. And because those bases are found in statute, for example, in RCW 49-060-040 sub 27. So this would just track with statute. And so it comes as a motion from the committee. And so what I would hope for is a second and then any discussion.
I'll second. And in support.
Any other discussion? All right. Again, a motion to support this. All in favor? Aye. Anyone opposed or abstaining? No. All right. Thank you.
Thank you. So we're going to move on to General Rule 11. The proposed amendments to GR 11 were not considered by the Rules Committee. Instead, one of the Rules Committee members, Colleen Melody, flagged this for me because I think I just missed it in a bundle of rules that were sent out for comment. So there's not time to have the Rules Committee consider it before the comments are due, which is April 30th. So I'm just bringing it directly to the board now. The amendments do a lot of things. I would encourage you to just hit the link in your agenda if you need more information. But at a high level, it would rename GR 11 from court interpreters to interpreting and language access to better reflect the scope of the rule and the issues that the rule addresses. It would similarly rename GR 11.1 from interpreter commission to interpreter and language access. And really what this is getting at in part is that the work is about much more than, for example, providing interpretation in a court hearing. And the amendments to GR 11.1 address providing guidelines on matters involving written documents of a legal nature, for example, which I think is really important. And given the importance of language access with respect to civil legal aid and unrepresented litigants, I currently see this most often in family law proceedings, where a lot of times the issues we have are with documents. So I'm hoping for a motion that the board write in support of the rule, which again, I would then work with the board chair to write a letter in support.
So moved.
Yeah, thank you. I'll second.
So Dave, are you making the motion and SB is seconding it?
No, it's Sal moved.
Sal made the
SB
motion.
seconded. Yeah.
Okay.
Mhm.
All right. Any discussion?
Just
Seeing-
briefly, I mean, it seems to me these changes are all make sense. I mean, they're not really controversial as far as I can tell, and they should be done.
Yeah. And I don't think they're controversial, but I think that this is something around language access that the board should lend its voice in support of.
As a board member, I absolutely agree. Expanding this beyond just interpreter services to all of the different phases of language access is something that we care deeply about. All right, so there's been a motion and a second. All in favor? Anyone opposed or abstaining? All right, the motion passes. Thank you very much, Judge Keenan. All right, back to the agenda. We have 3 other visitors with us today. We have a packed agenda. So, and we have a half an hour to go. So Michael, and then Jill Mullins, and then Sharif Sidiali from AOC. So 10 minutes each. Michael, I think you're going to update us on the legal regulatory sandbox.
Yes, thank you. And thank you to the Access to Justice Board for letting us come over from the Practice of Law Board and talk with you today. The Practice of Law Board does have a requirement from the court that we look at innovating and bringing new methods for the practice of law to the court. And the Practice of Law Board is currently working on such a proposal for a legal regulatory sandbox or legal regulatory lab. We're modeling this proposal after a laboratory that's running in Utah. And let me just take a little bit of a sidebar and explain what a legal regulatory lab is. It's really a set of processes that allow people to come forward with an innovative idea and get a modification to a rule that might have prevented that idea from being used or put into place currently. And what we do is we get an order from the Supreme Court to modify a rule for that participant in the laboratory to provide their legal service. They can provide a legal service for a period of 2 years in the lab. And then if there's no harm to consumers and the data shows that the rule change would be good for that, they would be admitted to practice under that rule. So let me give you an example of some that have come up in Utah. It might help clarify. For example, in Utah, there was a small firm which had a paralegal, which was a key employee of the law firm. They kept losing the paralegals to other companies that would hire them away because they could afford to pay them more. And so they came to the Utah Legal Regulatory Sandbox and asked for permission to give the paralegal an equity stake in the firm. Now, that's not allowed. We can't have non-lawyers as participants in law firms. So they were allowed to do this and were allowed to provide an equity stake to a key employee. So that's just one example of how a laboratory can be used. These labs or sandboxes are being used in other professions. They're used in financial services quite a bit and other areas. Key points about it, just to be really clear, it is not allowing people to practice without regulation. It's customizing a set of regulations that make sense for a particular legal service. I need to acknowledge as well that this, to a large extent, came out of the Access to Justice Board's Technology Committee. They've been looking at issues surrounding artificial intelligence, and they were even discussing perhaps writing a change to GR 24, which is our general rule which defines the practice of law. That's, the Practice Law Board looked at that. We worked with the Access to Justice Technology Committee to try that for a while and found that it was just really hard to do. And all the states have struggled in defining what the unlawful practice of law is. It's something that we all think we know it when we see it, right? When we see an unlawful practice, we think we know it. But that's also hampering innovation. Right now, the Practice of Law Board estimates that in Washington, there are approximately 50 online legal services providing assistance to Washingtonians in areas such as immigration law, divorce, challenging traffic citations. And these online services are guiding people through the process, and we're not really getting complaints about them. They are providing a service to the public. Many of them try to operate under a set of rules that were created between the Attorney General's office and LegalZoom, which allows LegalZoom to operate in Washington. And so a lot of companies are looking at that and thinking that it can be used to provide a safe harbor, which I do not believe is correct. So the Legal Regulatory Lab is a proposal. We're going to be taking it to the Supreme Court. And we provided to you our current copy of a very dynamic document that's continuing to grow called our blueprint. And that is the basis of our proposal to the Supreme Court. And we're trying to be public about it. If the Access to Justice Board has any input that they would like to have into the blueprint, or if they want to make a comment to the Supreme Court about this, we would welcome that. And I think with that, I'll just see if there's any questions and try to return some time back to your meeting.
Thank you, Michael. I appreciate that. Are there questions for Michael? Sal.
Just a comment. I mean, at least from my reading of this, Michael, it looks like a really good thought out proposal. I mean, a lot of it I think has to do with WSBA, obviously the bar, whether they're on board with doing what the PLLB is asking them to do. But I love this because, again, I think we have to be innovative as to trying to find other ways that people can access the legal system that otherwise can't access it. So again, just a short comment in favor.
Thank you. Other comments for Michael?
Terry, I'd just like to anybody can reach out to me after this meeting, and I am more than happy to go through this with anyone, because we've already gotten from Judge Corbett, who is our liaison, phenomenal feedback, which has helped us improve the blueprint. So I want to surrender the time back to your meeting, and I want to just say, please reach out to us at the Practice of Law Board. We've started working quite a bit with the Access to Justice Board on taxi cab and other matters, and we really appreciate working together as kind of sibling boards, because I think we're both trying to accomplish the same goals.
Absolutely. Can you put in the chat how people can reach you?
I will do that, yes.
I'm really interested in this, and I'm actually super curious about what Jim has to say about it also.
Haven't really thought about it yet. So thank you, Michael, for and the PLLB for kind of creating this.
Yeah,
So.
super interesting.
And Jim, just one thing I want to say is that we've taken into account that there are going to be a large number of nonprofit organizations who may want to come through the lab. And one of our hopes with this is that we would work with them and find a way to cover the costs of nonprofits participating. We know a lot of organizations that provide legal services pro bono are looking at automating those and using artificial intelligence and bringing them online. And so, we really, we're trying to have a path for those people through the lab.
It might really be worthwhile for us to schedule outside of this meeting a more intensive briefing and orientation to where this is all headed.
And we'd be happy to do that.
I would just add, Michael, for the benefit of the Practice of Law Board, the Legal Foundation of Washington, about a third of our grantees are making use of people with the triple LT designation. And so to the extent that this is an ATJ tool, I'm super interested. So.
Good. Well, I will put in the chat my contact information, and we are trying to be open and transparent. We're trying to get the best ideas from everybody. So we don't think the lab should be an evolutionary thing. We should learn and improve it, and learn and improve it.
And Michael, am I correct in remembering that you're going back to the Supreme Court in June? Or
it'll probably be in July, and that's when we're hoping to have something in place that they would be able to give us a. We kind of need a notice from them to either go further or that this is just something they're not willing to do, at which case we will try and find another innovation. And
it's as part of the process, trying to get as much widely diverse comments and stakeholder input. Yeah, we want to be able to say to the court that we've tried to talk to all the stakeholders. And so, yeah, anybody who wants to arrange a briefing on this, we'd be more than happy to do it.
Yeah.
Excellent. Thank you so much, Michael.
Thank you, guys. Bye now.
Thank you for giving me back a few minutes into the agenda. I did see that Jill Mullins now has access to be a host. So welcome, my friend Jill Mullins.
Hi, everybody. My name is Jill Mullins. In my day job, I am an attorney, a staff attorney at Northwest Justice Project in our Native American unit. And I also am the WSBA at-large member of the Pattern Forms Committee, and also serve on the Domestic Relations Pattern Forms Committee. And I was asked to give you an update about some of the things with the Pattern Forms. And it has been, I think the last time I presented was in 2018 to this board. So I thought I would just give like a general overview of the Pattern Forms and some of my thoughts on where we're at. And I created or modified my old PowerPoint to sort of give you guys an overview. So that's why I'm going to try to share my screen and see if we can make it happen, and hope that that means that I can do it quickly and not take up too much time. Since I know, let me see. Let me try that again. It seemed to have, can you all still hear me?
Hear you, yes.
Excellent. Everything was frozen there for a minute on my end. Okay, so let me just hit play. So the Pattern Forms Committee is tasked with trying to break down barriers to justice by creating accurate and easily accessible statewide forms. And we do this by creating Word and PDF forms that are available on the state court website. There are, I think, easily more than 500 forms on the state's website. And we try to have them grouped by area of law, and then also by the forms sort of naturally flow in progression. So it's, if you were to look at it and look for an issue that you were working on, so if you were to do a divorce, you'd see the summons, the petition, confidential information form. You'd see all the basic starting documents first, then you'd see some of the stuff that happens in the middle, and then you'd see the stuff that happens at the end towards the end. So a lot of the
Jill.
time, yeah.
Just wanted to make sure you knew that we're only seeing you. We're not seeing any screenshot.
You're not seeing any screenshot.
No.
Well,
which is fine. Just wanted
totally
you to know.
fine. I did not know that, and I will try sharing the screen slightly differently and seeing if that helps. Because it says I'm sharing the screen, but I also had a weird freezing issue when I tried to share the screen. So we'll try it one more time. If not, can you all see now?
Now we can.
Okay. So yes, so we keep the pattern forms are on the court website. So that's what this screen is what it sort of looks like when you're on the website, and you can see, you can click on and get the Word or the PDF and see all of that. And so that is how they're organized. So the Pattern Forms Committee has been in existence since 1978. When I did the presentation in 2018, there were 829 court forms. I don't know how many there are today. There are almost 100 volunteers. So in addition to having the Pattern Forms Committee, there are subcommittees that have experts that do the drafting. And on basically every subcommittee, there is somebody from every layer of interest. So you have clerks, you have and ideally private attorneys, you have government attorneys if it's something like criminal or something like that. You have somebody from the bench, so you have a commissioner or a judge on the subcommittee, and you try to and have basically all the folks who might have knowledge of what will make the form workable. And all of these people volunteer their time, and sometimes it's a ton of time. And actually, I forgot to update, Mary Gow is no longer with us. Ashley Tam is, and then there are several other folks. There's been a whole lot of transition in the last couple of years. And so, and that's been sort of an interesting time period of just all of the transitions of different ways of organizing. And instead of having sort of one person who, like that Mary did, that sort of does everything, things are separated out a bit more. So one of the main things that have happened in the past for access to justice things is there was a huge effort to get the forms into plain language. And so that was a really amazing project that has been done. And then the challenge is to always make sure that we don't drift back into legalese. There is been, there's efforts in just trying to understand how to place the forms, how to make them accessible. Northwest Justice Project in particular has created, through Washington Law Help and some work there, ways in which you can now fill out a lot of the forms online using their system. So if anybody's ever done family law, it would be, in my mind, a much better version of Family Soft for pro se parties. And then the big task is that the law is always changing. So in 2018, there were huge major changes. It required lots of new pattern forms. In 2021, there was the huge major change to the non-parental custody statute, where it turned into the minor guardianship statute. So all those forms had to be removed, and then brand new forms had to be created. And there were, and then on top of that, just every year, forms need to be updated sometimes because there are tweaks or somebody discovers an error in a form. There's a form on the web, there's a spot on the website where you can notify that there's a concern with a form, and we also go through and collect those. They get added to a spreadsheet, and we just review them and try to make sure that the forms, they're always a work in progress. And because of that, one of the biggest challenges to equitable pattern forms is language access. So right now, I was pleased to see, I didn't realize how much had been updated. When I last spoke with you, there were almost no forms that were current in terms of translation. There were just a few Spanish ones that were. But when I just looked, we now have Korean, Russian, Spanish, and Vietnamese that have not all the forms, because that's a lot of forms, but trying to identify and get the most used, most necessary forms translated into multiple languages. And so it's really exciting to see this has happened. And also, it is something that will always be a perennial problem because of the fact that there are changes that happen all the time, and the forms need to be updated, and making sure that the forms in different languages get updated. And of course, trying to add to this list, because we have so many other languages that are spoken by significant members of our state. And so, you know, as was talked about earlier, how do we make sure that we have language access in more than just translating in the courts? When I last spoke to you all, I talked about the forms and really spoke about the problems with making sure that they're gender neutral and also sort of sex neutral. And so the Pattern Forms Committee has been on an overall process to try and make it so that every time we do the forms, we're creating more neutral language. And so in some of the things that you see, like law enforcement requires you to check male or female, but whenever possible, we have tried to make it so that it says, so that we say, instead of male, female, we'll say sex and leave it blank so that people can fill in for themselves, and not force folks into the binary, especially because we have an official X gender category in Washington. And as of this morning, the federal government announced that passports and everything like that will also be able to be have an X option. And so it's just really important that our forms be able to match people's identities, and also what is the like facts on the ground. And there, you know, it often means that you use more words, but you can easily say person who pays expense or something like that when you are, there are ways to make things gender neutral. And then the other thing, and I'm sure that this committee has talked about it a bunch because it comes up when we're trying to figure out how to create equity, is the burden of not having a unified court system. And so while we can try and do a bunch of things at the pattern forms level, many counties create their own forms, and they don't necessarily adopt the same efforts to make things in multiple languages, efforts to make things gender or neutral in a way, so that they're not discriminating against folks who are not either heterosexual or cisgendered to the birth that they are assigned. And so that's kind of where we're at in the history of the forms and sort of an overview. If y'all have any specific questions, I'm happy to answer them.
Thank you very much, Jill. And I think you can stop sharing your screen so we can see everyone. That is just a tremendous amount of work. And so we appreciate your efforts. Are there any questions for Jill Mullins? Well, seeing none, thank you so much for sharing that with us. And it is remarkable that we have probably 1,000 standardized forms, just pattern forms, just remarkable. And that has always been, I think, an access to justice issue.
It is, and it's definitely a challenge because there are so many forms, and how do you, it is an incredible challenge to track them, make sure they're all accurate, make sure that, you know, all of that. And I know that it is a huge task that the AOC, you know, they don't necessarily have all the staff that they could use to make that something where people aren't working insane hours when we have deadlines. There's a lot of burden that I think is pushed on the AOC staff to get these forms done. And so, yeah, a lot of recognition and respect for that incredible amounts of effort and organization that happens with their office.
Thank you so much. So Sharif Sidiali is our third visitor for the day, and he just turned off his video. And you're back, but you're muted.
Sorry, I was just making sure my internet is working properly. So that's why I had to turn off my camera and then back on. Well, hello,
Welcome.
everybody. Good morning. Yes, go ahead, Terry. I'm sorry.
Oh, no, go ahead.
Again, good morning, everybody, and thank you for the opportunity to be amongst you, giving you a little background about what we do, but the equity and access to justice, a program that's been launched by AOC. And I wish I had more time, but I had only 10 minutes because, as we all know, I mean, we face a big problem in our judicial system, in courts, especially for the unrepresented litigants. May that be with language, with form, with just a bias issue. So it is a big problem we face. And our equity and access program, new program, has a core purpose. And that core purpose is to help our state courts develop solutions for unrepresented litigants, and those who experience barriers in the court system. Not only that, the new program also will allow us to hopefully engage in a strategic partnership with organizations that serve those same people, the unrepresented litigants' needs. Just a quick example, because I've been visiting some courts lately, as just to find out how these people are being treated, what is the system doing. And in some courts, I was really impressed by the way some judges and some court staff are treating these people. In other courts, I wish I could say the same, but it's not the case, and it's kind of really concerning. So I am here today to just talk to you about our vision, our mission, and then that's just ask something that you probably are going to be playing a huge role in fulfilling our request as a board. So our mission, as I said, is we're committed to advancing equity and fairness and justice, especially for people who are not represented, who are marginalized. And our vision, we built it close to what we say, no child left behind. We are saying no one is left behind in this. Where nobody will be left behind from what we're trying to achieve and accomplish, to have fair access to justice and treated equally, no matter who you are, where you come from, what you look like. So that's our vision in simple words. Our objective are to find out what is going on, to explore, to identify the problems that exist, the barriers, to collaborate with other disciplines, to review policies, to look at laws, to provide technical assistance, training, and support to courts. So we have so much work to do, and we are really excited about doing this. In fact, we started for this new program, we started hiring people. We already hired an administrative assistant. There was interviews 2 days ago for a program analyst as far as relations with tribal communities goes. So we are in the process of moving really fast with this program, trying to bring on board the people that we need so we can actually start the real work and and hopefully get this program off the ground and push for equal access to justice for everybody. So I don't want to take too much time, but if I may just share this one slide, Terry, if you can give me, I'd like to share this one slide here. I feel like this is the,
I think you can now.
Yes, let me just go through this, hopefully. Okay, let me see what it is. And I'm coming to you today, to the board, because we need this call for you. We've been having so many issues, which we feel really are a problem. Court facilitators who I've been having meetings with are really.
Well, we don't know what John and Jen are suggesting. I think the
Cesar, yeah, there you go. He's now muted.
I'm sorry.
Go ahead. Somebody was unmuted.
Oh, so I'm sorry again. Court facilitators who I've been meeting with, they are really frustrated and they are stressed and they need help. And I'll go back to just one slide that, let's see here. Okay. This is their concern that from talking to them, I'm going to try to see if I can get to the list of concerns, just to give you an idea here. This is what their concerns are. Just these are some of their concerns, not the entire. There's a mile-long list of concerns they have, but this is what they've been expressing, and they need help. They said we cannot do our job and our work and serve people who come to the court if we don't get this kind of help. And then the interesting thing is that they need support from management. They feel like they are on their own, that there is nobody they can talk to who they can help them. So that's just giving you an idea, and we're trying to make them feel good. So we told them we're going to be helping you. We're going to be hiring a court facilitator, an analyst who works directly with them, help them and support them. So it is, and this is what I come in. This is why the meat of this presentation is this one slide. We need the ATJ board to help us to have this new program, the Court of Innovation, to assist us, with attorneys and training for the courthouse facilitators. We need them to assist, attorneys to assist with creating resources for facilitators, help us designing website for self-litigants, and then also, find out what areas courts can create barriers for their clients, which areas need to be addressed, which areas need to be worked on courts. And because, I'm just going to give you an example here, throwing in there, as Hugo Chavez said when he was running for president for Venezuela, I could not have done it without my people. And I'm saying here, we could not do this job and grow this program without the ATJ board helping us on this. It's not just financially, but also other resources to be able to provide that access to justice for everyone in the state of Washington. I thank you so very much for the time, and that's all I have. Thank you.
Thank you very much. And we will, there was a question in the chat about whether we can get the slide deck sent to us. So if you send it to Bonnie and Diana, they will forward this out.
With a pleasure. Yes, I would do that.
We will review it and consider how we can help.
Sure.
All right.
Thank you so much.
Thank you, Sharif. All right. I'm sorry we've run a little long. I would like to, in the last 5 minutes, borrow a little 5 minutes from Goodwill and touch base with Kara and Caitlin about Equal Justice Coalition. Cesar and Jim are here for the federal and state funding. Natalia put her report in the chat. So Kara and Caitlin, anything to update us on?
This is Kara. I will be really fast. So on the EJC staffing update, you have me because we don't have a director of communications and advocacy yet. Applications are in. We understand they'll be reviewed next week, and our goal is to have somebody on board by mid-April. So you'll get to meet them hopefully at your May 6th meeting. From a federal level, we are doing some preliminary planning on the 23 options for trying to secure an increase in LSC funding. We're happy that President Biden's proposal for the LSC budget next year is $7 million. And I think Cesar can speak.
700.
700 million, sorry. See, I'm really bad with the numbers. Cesar knows this. I have to write them down. I have it written down and I still said it wrong. Anyway, so I will hand it to Cesar for the next bit of that.
Hello, I'm sorry. Did you want to add anything else on the EJC side? Because I'm on the agenda for the
Okay.
federal.
Well, then I have a couple other quick notes. OCLA has issued or sent out its 23 budget priorities. So the EJC is working with stakeholders, encouraging them to respond directly to OCLA, particularly on the funding partnership priority. Looking back, we understand that discussion was kind of put on hold by COVID, so we're excited that it's back again in the priority list. And EJC is also working to do its own response that addresses the alliance position as a whole. And then we're also doing some stakeholder work, evaluating resources available to stakeholders to enhance their community-informed advocacy, with the goal of highlighting the community needs in future funding requests so that we can increase funding for civil legal aid. And that's it for me.
Thank you, Kara. Caitlin, were you going to add anything or?
What she said.
What she said. Excellent. So Cesar, to you and the federal funding.
Thanks, Terry, and thanks, Kara. I appreciate your jumping in, given that we're missing a director, a JC staff person, I should say, and the need to the traditional role and historic importance of the EJC maintaining LSC funding as a high priority for our congressional delegation is certainly much welcome and needed. As Kara mentioned, Senator President Biden has proposed, they've just issued their budget for the 23 fiscal year, and that includes $700 million for LSC, or proposed $700 million for LSC. And just as a reference point, I think last year it was $600 million. And as the budget process played out, the ultimate number was only $483 million, which was far below what the different budget committees have proposed. At this point, the budgeting process is just getting underway, so that both the House and the Senate and their various committees are going to start developing and fleshing out their positions. We would expect that the House would be closer to the 700, if not above it, and the Senate would be far below. In 2021, the spread was 515 million proposed by the Senate and 600 million proposed by the House. At the end, it was $483 million that the budget played out. Kara's reference to starting to reach out and touch bases with some of the congressional delegation, notwithstanding the fact that we're not going to be traveling or anything like that, is, as I said, great. And I really appreciate the work, even though we don't have the staffing. Frankly, the mismatch between the funding requests or proposals by the president and the request by LSC and the National Legal Aid and Defender Association, which again this year is going to be for $1 billion or more to make up for the disinvestment in legal services over the years. So there's still a big gap there. Unfortunately, at this point, JP is very focused on the impact of the much less than anticipated funding, which is having some pretty serious consequences for us. And we're engaged with our union colleagues in negotiating some kind of a staff reduction process as required by our collective bargaining agreement, and that's taken up a lot of our time. I don't have anything else to add on the federal side. Oh, I will say one more thing. The administration has, as they did last year, proposed to lift the entity restriction, which is the restriction that basically led to the creation of NJP in the first place, because it made the restriction, the prohibitions on federal funding apply to all private money. That has traditionally not gotten a lot of traction in Congress because of the commitment to being either nonpartisan or bipartisan effort, and the concerns that the Republican Congress folks have are very much built around immigration and not allowing immigration representation and things like that. So don't expect a lot of movement on that front. That's all I got, Terry. Thank you.
Thank you, Cesar. Jim. state for me.
Thanks, Terry. And I'll be very brief. I just wanted to touch base on 3 initiatives that we are moving on as a result of the 2022 legislative session. The first is undertaking a new approach to rethink and retool our investment with an increased appropriation for eviction defense services. We're talking about services for tenants who do not yet have who are not yet eligible for right to counsel services because they haven't had a case filed against them. That process is being undertaken by Philippe Nab and the eviction defense team. We also were pleasantly surprised to see a $2 million appropriation for continuing funding dedicated exclusively to civil legal aid services for victims of domestic violence. Following conversations with the proponent of the proviso, we have an agreement that 25% of those funds will be focused on a notice of funding availability targeted to domestic violence victims who live on or near rural and remote Indian reservations, one of the biggest deserts that we have in terms of the availability of legal assistance, and one of the highest areas of incidences of domestic violence. The other is a general notice of funding availability for services targeted to victims who are members of communities that are most at risk and most unable to access services that they that are available through traditional domestic violence relations, domestic violence service organizations. Those will be coming out sometime in April. And then finally, we received another surprise. There was a $350,000 appropriation to establish a kinship care provider hotline staffed by 2 attorneys. We are going to basically move that commitment and that effort over to the King County Bar, which currently carries a contract with us for kinship care services and support. KCBA has graciously said, yep, we're in, we'll do it. Really appreciate Dua and her team. And that's all I got.
All right, thank you, Jim. Caitlin, anything on LFW to share?
Nope. All we've shared all between Kara and Natalia's report.
All right.
Speak, Terry.
Thank you. There's also, John put in the chat about the Unemployment Law Project Brew review is coming back, which is quite exciting. So thank you all for your patience today when we ran a little over. Thank you, as always, to Diana Singleton and Bonnie Sturkin, without whom we could not do this. And to Lindy Lawrence, the door's always open. And thank you. We'll be seeing you next month. Bye.
Bye. Have a great weekend. Bye.